I request you to share with the participants your journey in environment litigation.
Sure, sure. I would. Though it has not been like a vast experience of decades, but yeah, in my limited experience of the last 7, 8 years, I could say that, um, as far as developing sense of how environmental law or how environment really works in the minds of judges is something which has been a very uphill task for us. And this actually changed a bit when the NGT had started to function back in 2011. And eventually we could see that with the help of a technical member sitting on the bench along with the judicial member really helped in arguing and understanding the consequences from long term as well as short term consequences of any environmental issue that we have brought up. So this was something which has been a good, really good output as far as the judicial mechanism functions. But as far as the government functionaries function and the whole executive and legislative domain apart from judiciary that is concerned, we are seeing a massive downhill from 2014. In fact, there has been a concerted effort to dilute every environmental legislation every year, and we are seeing that happen to all important notifications like environment impact assessment, EIA. I'm sure all of you or most of you may have heard about the huge social media backlash that EIA draft EIA, which was supposed to be the new EIA in last year, was also completely favoring the industries. The No, nobody's against development per se, but the idea that development will always have a higher role when it comes to protecting environment is something everyone was against. And we have seen, even with coastal protection laws, even with protection of national parks and wildlife sanctuaries, see what's happening in Lakshadweep, see what's happening in Andamans. So situation has been dire, and in fact it is the need of the hour to have more people come in, join, and understand to what extent because it is our generation that needs to now take control for our future. That is something, and also for the next generation. But our generation is going to see a huge change in decades. One decade after the other, there will be a massive change in environment that will directly affect us in every part of the world, including Mumbai. So I think it is a very, very serious issue. It is somewhere also an important issue of livelihood as well as life and death, because there will be massive climate refugees in future. Is what we are perceiving. In the next 10, 12 years, there'll be people moving from one part of the country to the other. And with policies not being up to the level of science that is now which is an accepted science of what's going to happen in future, is something we need to be really careful and push our government to come up with such important notifications, laws that help protect our future. So with that, I would say there is hope, obviously, with more people joining, but also at the same time, there's a lot of work now. I would say the work has increased by multiple times for protecting the environment, and there are not many people around. So with that, I mean, this is what has been the experience so far, and with this, I could proceed with our.
Yes.
So basically, here today's topic is I would say very important from a practical point of view. In theory, we do read everything. We do read a lot when it comes to jurisprudential concepts and approaching courts and how judgments come out, and we love reading judgments. But the kind of strategies, drafting, research that gets undertaken prior to your judgment that is released by a court is something which is of significant importance. No judge will be able to write a good judgment unless a case is presented well to that particular judge. This is the golden rule to understand. The role of lawyers, counsels, oral presentation before the bench is extremely important to get a very good judgment that also reads well later on, and that's where you help shape the judicial conscience of the court, as well as you help shape society. So with that backdrop on the seriousness involved when it comes to understanding practicalities of environmental litigation, I can start by saying that environmental litigation definitely covers both branches of law, which is the civil as well as criminal, though most of it is obviously covered under the civil. So I will touch upon both and also, in fact, tell you where we are lacking behind in terms of the criminal branch as far as application of environmental crimes is concerned. Is absolutely lacking in many terms, which we'll touch upon later. But we'll first begin with civil. So when we discuss civil, there are certain remedies that are available for in this field, in this particular branch, which is that once an environment has been destroyed, you seek something in the nature of remedifying it, and you seek something in the nature of bringing that particular damage back to its original position of whichever environmental this thing area, be it like a forest area, be it a mangrove area, be it a coastal area, intertidal area, mud flat, whatever it be. You need to first jot down what are the remedies that you're looking at whenever there's a case that comes to you. So in civil remedies, you have application of polluter pays principles. You can seek imposition of environmental fine against the violator. The violator here could be a private body or a state agency or a public body. So civil remedies would include such remedies. And to begin with, how civil branch can be worked out well, we need to understand the fact that any environmental issue or any issue of environmental law is completely in the domain of public law. It's a public law remedy. Environmental issues mostly cannot be seen as something which is private between X and Y persons. Always and always, as Justice Javed Rahim in one of our matters before the NGT Western Bench had said, that when you bring up an environment matter before the court, environment is always a party in absentia. It is always a party in the proceedings. A public law will always be involved. Public law element will always be involved in such issues. So when we are thinking, there that is where we start thinking, okay, maybe then that's how even environmental laws are used in filing public interest litigations, and that happens so in the high courts. But now I want to clarify very important thing under the civil aspect of environmental litigation, which is that what is the correct forum to choose when it comes to filing an environmental case. Now, as far as environmental litigation goes, there are two forums on the civil side, which is you either invoke NGT and or you invoke High Court. Now, the position in constitutional law is very clear. If there's a particular tribunal that has been enacted for a particular purpose, then you cannot invoke Article 226 and run to the High Court. You have to go before that tribunal, unless there has been a case of you have not been heard, or the tribunal is not sitting, and you are invoking an extraordinary jurisdiction of the High Court because NGT cannot hear for XYZ reasons. But assuming that all such legal technicalities when it comes to jurisdiction are kept aside, and you go ahead with the fact that NGT is fully functioning as well as High Court is fully functioning, then how do you choose between two forums? The very first aspect that you need to look at is read the NGT Act. Since NGT is a special tribunal, National Green Tribunal is a special tribunal for all environmental issues, it becomes a bounden duty of any lawyer, of any person who wants to approach court for an environmental remedy, to first read NGT Act. Why I say so is very important, because NGT Act deals with uh, two kinds of jurisdiction. One is the original jurisdiction, which is under Section 14, which I'll explain in a summarized form just now. And second is the appellate jurisdiction, which is under Section 16 of the NGT Act. Now, Section 14, original jurisdiction, deals with all your general public law related issues when it comes to, for example, pollution of a particular river, which has been, for it has been polluted. You know that you are seeing this river been polluted for over 10 years, 12 years, and even today the situation remains the same. So you're sick of it. You're thinking, why is it that the river is not getting cleaned up for so long? So you send a representation to the government, and if they do not respond, then you approach the NGT. Now, when there are issues where there is no particular project involved, where you are going out, where you are challenging some environment clearance or forest clearance, where you are not doing any of that sort, when you're only and only going for remedifying a particular environmental wrong, then you invoke Section 14. Then you invoke original jurisdiction, where you are seeking cleaning of rivers, where you're seeking cleaning of water bodies, where you're seeking to ensure a particular kind of activity must be included within the regulatory framework of an environmental law. Then you invoke Section 14. So basically, the language that is used in 14 is also that any question relating to substantial question of environment and any legal right relating to it, will have to come under section 14. So it is very widely worded. Any environmental wrong that you feel which is happening as on today, you can go after that, as long as you're not seeking a private remedy against a particular developer or else a particular project proponent, I mean. Or else you can also go to under section 14 when you have certain kind of clearances already been granted by the authorities and they are not complying with it. When they're not, there are certain conditions that have to be complied, they're not complying with it, so you go after those conditions to be complied with under 14. Now what is section 16 is the entire appellate jurisdiction under NGT. Now, appellate jurisdiction, it means that it can directly hear an appeal against on merits against any environment clearance or any forest clearance or any coastal regulation zone clearance that has been received by a specific project proponent in a specific area received by the concerned authorities. So you can directly file an appeal within the limitation period that is given, which is about 30 days, 30 plus 60, and you can proceed with filing an appeal and argue your matter. So this is the appellate side of the jurisdiction that NGT enjoys. So this is where the two jurisdictions function in the NGT. And now another very important point to keep in mind is that NGT has something called a Schedule 1 to the Act itself. That clearly lays down under which are the laws that NGT as a tribunal can take cognizance of. And there are 7 legislations put down there, which is all cases that arise out of Water Act, Air Act, Forest Conservation Act, Environment Protection Act, then you have Public Liability Insurance Act and the Biological Diversity Act. So these are the laws that are laid down under Schedule 1 of NGT, and it is only when there's an issue that's involved in these enactments, only those issues can go and can be filed and NGT can take cognizance of. The rest of issues arising from other enactments, and those enactments being Wildlife Protection Act. Now that is not included under Schedule 1. Or you have the Indian Forest Act, and that is also not included under Schedule 1. So for some acts like these, you have to only the remedy that you look for is either you file a complaint before the magistrate, because both of these enactments like Indian Forest Act and Wildlife Act also has some criminal enactments, given provisions that have a criminal nature, provisions which are of a criminal nature are also included under these enactments, and that was the very reason why these enactments were not added to the NGT Act, because there are very complex issues involved. For example, if we take a Wildlife Protection Act, there's a very complex issue regarding illegal wildlife trade, which have a quasi, which are all such questions and issues are of quasi criminal in nature. So now to also, which is being that entire jurisdiction which is already being handled by criminal court, now to also get NGT to handle such issues would become a question of a big confusion. So, and not just questions of or not just provisions of criminal nature, but also provisions such as under Indian Forest Act you have something like settlement of forest rights of certain tribals or certain forest communities. When an area is being declared as a reserve forest or a protected forest, that is declared under an Indian Forest Act. Within that Indian Forest Act, you also have, once you declare an area as PF or RF, then eventually you have to also settle some certain rights of forest communities, because not all human intervention is allowed when an area is declared as a reserve forest. But if it is declared as a protected forest, then certain human intervention is allowed, where you can where the forest tribal communities can still reside within the forest, subject to all the processes that are involved. So to avoid that complexities involving settlement of forest rights, as well as to not get confused over invoking provisions which are quasi criminal in nature, these provisions like Wildlife Protection Act and Indian Forest Act have been kept aside, have been kept out of NGT Act. So now whatever rights that you want to go after, or you want to seek remedy within these two enactments, Forest Indian Forest Act or Wildlife Protection Act, you have to take either the route of the High Court, or if it is very specific to a particular case, then you may have to take the option of going before the magistrate. So this is where the difference lies. So no particular issue that deals with Wildlife Protection Act, as an example, can come before the NGT. It is very clear. If at all there are overlapping provisions, there is always the possibility of having overlapping issues. one that deals all not only with Forest Act but also with Wildlife Protection Act. So Forest Conservation Act, which is included in the NGT and not Indian Forest Act. Forest Conservation Acts deal with granting clearances and all only. So when there are issues of both national parks, sanctuaries involved, as well as something like under Forest Conservation Act or Water Act, then you have to segregate issues. You can't combine them all together. You have to only take all those issues arising out of the enactments in Schedule 1 of the NGT, combine them, put them together, and go before the NGT for those issues. As far as wildlife related issues are concerned, you have to take the route of another forum, which, in my opinion, on many occasions, when you go by way of a PIL, it has to go before the High Court. There is no other source. So this is the distinction that has to be kept in mind. Why the importance of Schedule 1 of NGT Act is something you need to keep in to be always aware of. Now, right, if we just continue on Schedule 1 for maybe 2 more minutes, I want to point out that there are actually 7 enactments. One of them is Water Cess Act, which is like a taxation related act, but that has been repealed after the implementation of GST. And that's how now we only have 6 acts under the Schedule 1 of NGT. Now, also one thing to keep in mind, the question arises then, if these are the acts, what about the rules? Something like, solid waste management rules, something like coastal regulation zone notification, something like EIA notification, environment impact assessment. So what happens to these notifications which are in the nature of subordinate legislation? So all these notifications are most of the times, in fact, always issued under Environment Protection Act itself. So they are in the nature of a subordinate delegation which has been given to the executive body from Section 3 and Section 5 of Environment Protection Act. That is the mother act, that is the parent act of all these rules which deal with specific subject matters. So your solid waste management rules, your plastic waste management rules, biohazard rules, hazardous waste rules, biomedical waste rules, postal regulation zone notification, EIA notification. So they are all not enactments of parliament. They're all subordinate legislations issued by the executive under by getting powers from Environment Protection Act. Hence, all these notifications are also within the domain of NGT Act because they are all issued under the Environment Protection Act, the parent act. So all around 60 to 70% of major environmental issues will go before NGT, but other major issues under Wildlife Act and Indian Forest Act will go before the High Court. Now, this is the distinction I want to make it clear before you guys to know which forums to choose because it can get sometimes confusing. Now, I have already dealt with the fact that NGT includes 2 jurisdictions, the Section 14 and Section 16. So when you file a Section 14 application, it is called as original application. And when you file a Section 16 application, it is called an appeal. Why is it called an appeal? Because you're filing an appeal against any of the clearances that has been given to a particular project. So this is the outer idea of basic foundational idea of how NGT and the High Court's forums have to be chosen. Now, let us come to the core of the issue on how we have to research, draft, strategize, and present in court. Now, very important to understand in issues of environment law is that science plays a huge role. And I really do not think there are many other branches of law or other specific areas of law other than environmental law where the importance of technical knowledge of that particular field is really important, except for something like intellectual properties law or taxation law, where you need to have some technical knowledge of taxation formulas as well as intellectual properties comes to engineering and all of that when patents are being filed. So there are some 2 3 areas of law which require technical expertise. Environment also forms part of that branch, which means that the work of lawyers when it comes to environmental law is always at a higher pedestal and more important from the point of view of understanding non-law, from the point of understanding the science behind every case that you're going after. And by that, it doesn't mean you need to have a background in science, nor does it mean that you need to have a complete understanding of chemistry, biology, physics, and formulas and arithmetical formulas, calculations. No, nothing of that sort. But you need to have an open mind to understand how ecology functions. For example, if you pick up a subject which deals with reclamation. I'm taking Mumbai Coastal Road as an example. You pick up the understanding of how intertidal lands that exist all over our western coast, and just read and understand the basics of how it helps protect the sea, protect us from flooding, how the intertidal or mangrove areas, mudflat areas help in ensuring that the waves of tsunamis that may come arise in future are not as strong as it is expected to be. So this is the idea of understanding the real value of all the natural areas that we have. Even for example, you talk about something like a national park that we have, Sanjay Gandhi National Park, or any forest areas. So when you read and look up and you understand that, okay, this huge chunk of forest area actually helps in sequestering carbon or taking in carbon, which is literally 10 to 12 times how much a lone plant does. It is something which plays a huge role in making your arguments better when you argue out. Because as far as environment law is concerned, you have only few doctrines which are of environmental jurisprudence. Some of those doctrines are something like polluter pays principle, sustainable development, intergenerational equity, which basically means that every generation has the right to all natural resources that we have, plus something like doctrine of non-regression. So there are some jurisprudential concepts which are not plenty in environmental law, because science does play a big role in your arguments before the court. Now, that is where these are the caveats that have to be ingrained in your mind before you commence any environmental law related work. So now, when we pick up how to begin when a case or a brief comes to you, first thing, again, as important, golden rule in litigation is research. Before you draft, you need to know what is the issue and how the general law in that particular field, in that particular issue, is uh, concluded, whether there has been any concluding aspects by or concluding ratio given by the Supreme Court or your relevant High Court. You need to look into that angle. That is your first research golden rule, the judicial pronouncements made in that particular subject. Eventually, what you also need to know then when it comes to an environmental issue, then is after your judicial research, you need to do your scientific research. You need to look at articles that deal with something which is in the nature of, as an example, again, I'll pick up, if a reclamation is happening in mangrove areas, in the coastal areas, you need to look at the consequences of reclaiming or destroying mangroves in certain areas or certain parts of the country. And especially if your particular area, for example, Mumbai, has been studied upon by certain scientists from different institutions, and there is like an article put up which says that these will be the consequences of rampant reclamation in Mumbai, and we will see that flooding will increase multifold times, and it's all included in a nice scientific research which is a part of certain journal. Then that becomes another primary source of your legal arguments. It becomes a prime, because nobody, one thing to be kept in mind is, if you find a scientific evidence that is completely in your favor, then your half of your case is done, because there can never be any arguments on science. Once a scientific fact is concluded on a particular issue, that acts as the best evidence and actually as the best argument for you. It cannot be that there is some different kind of science that has been put up by the respondents to show you that you're wrong. If you can show a peer reviewed journal dealing with a certain issue that you have, and they have already done it scientifically by way of an article, a huge that particular study may have also conducted site visits, and they must have reached a particular conclusion that also talks about what are the suggestions and recommendations. Then you can inculcate those recommendations, suggestions in your draft when you're filing your petition as well. So the importance of scientific articles, journals for any issue when you're dealing with is actually on par with any judicial research, in my opinion, when it comes to environmental litigation. So one cannot proceed without knowing the other. So this is very important to keep in mind when you do your when you take up any environmental litigation. Now, another important aspect of research while you are on your issue is that you need to keep in mind what are the national policies for that particular field of environmental law. Why I say so is because today Environment Protection Act is still a very widely worded notification or legislation. and a lot of power has been given to the executive body to come up with all sorts of notifications and GRs and circulars whenever they would like to. So for any issue, just I can give you one small example, something like as small as how to carry out aquaculture activity inside a water body. Now there is no enactment when it comes to that as far as Maharashtra goes. It's an absolutely unregulated activity. Now tomorrow a particular circular can come up and say can come up from the executive body, from the government department, that says okay, we are going to regulate aquaculture activity by X, Y, and Z measure. It could come up with that. But at the same time, since you do not generally tend to have, or you will find loopholes or gray areas where there are no such notifications, no such circulars that clearly regulate something of this and something of this particular issue that you're coming up, there is no regulation per se, then you need to start looking at whether there are any national guidelines, whether there are any national non-binding research framework document that has, which is called RFD, any research framework document that has been set up. Because even with each ministry there are certain different kinds of departments. For example, Ministry of Environment has different departments under wildlife. It has departments of wildlife, it has departments of inland water body, coastal body, so they have different departments. Each department, sometimes when there are good IAS officers and there are good bureaucrats sitting there, also end up having the documentation of particular guidelines that how things should function. They're completely non-binding in nature, but if you get your hands on these guidelines of that particular issue that you're dealing with, attach it, you need to use it in your uh, cases. Why? Because somewhere, though otherwise it will, if because otherwise guidelines, like you all know, guidelines are something which are non-binding in nature and only have persuasive value. But if you find the fact that if you come across a fact that this particular issue is absolutely unregulated, and then you have certain guidelines, then you can really help the court to convert those guidelines into the primary source of law for that particular issue. And that has occurred, that has happened. NGT has also done it time and again. But this is what I want to bring up into your mindset, that do not just leave everything as it is if you find that that particular activity is completely unregulated. There are higher chances that you will find certain guidelines issued by some ministry on dealing with this aspect. As also a law, if you guys know about it, that land and water is a state subject. So any particular issue around, because environment is everywhere on the land and on water, there could be certain issues like of, for example, for protecting wetlands or for protecting paddy crops, that also helps environmentally a lot. For those issues, if your state does not have a particular legislation, then you are free to look at other states, do a research, comprehensive research, whether other states have undertaken or have certain legislation which are covered, which where it covers many aspects, all those issues that you have. Though obviously it's basic sense that legislation of other state will not apply to you, but you can help build up a case to that particular court to say that look, this cannot be left unregulated when states like, which we often see, Kerala or Andhra Pradesh, have already had a particular mechanism to regulate it. So you can also ask in your plea to regulate that particular issue which is lying unregulated by giving examples of how other states are regulating it. So these things you need to always improvise, and if you find something which is not here, not found in this particular state, whatever you're looking at, then feel free to look at other states and then take up points which actually help you and put it as your suggestions in your application before the court or PIL before the court. So this is the research angle to know, to be completely clear before you begin drafting. Another part of research is that, assuming for a moment you do not get any sort of the issue that you have brought up is so unique, mostly in the chain, which is in the nature of climate change, future climate change consequences. This kind of issue is something which Indian research organizations are lagging far behind compared to world studies that have been done. So if you are not finding anything which is centric to your country, to your region, then always look beyond your borders and look at what UN bodies, UNEP, United Nations Environment Program, World Health Organization, how in fact even we will be surprised to know even World Bank has now started to come up with its index to show how economy gets affected because of, or how it will get affected because of climate change and global warming in tropical countries like India. So you need to expand your research to go outward and reach out to also international scientific articles or international scientific uh, research that has been done by top bodies, top global bodies, which have which command huge you know respect as well as huge source of international law. So you could also bring that down, put it in your drafting, put it in your research, put it in your application or the PI that you're filing, and then explain to the court why this is a requirement in this at present, and why this particular field of law needs to be regulated or XYZ, whatever the consequences have to be, whatever remedies you're asking, why those remedies have to be allowed. So this is the expansion, this is the outward looking way of conducting your research. Now, when it comes to drafting, I think drafting is of a case, of an environmental case rather, is has many golden rules which are also applicable to your litigation, to your any other litigation case. For example, something like maintain chronology of events when you're drafting something. Do not directly jump to something in your facts when you start writing the facts of the case. Do not directly jump into the main issue involved and you try to just show on this date this happened in 2019, on this date this happened in 2019, and suddenly then you jump to 2017 because you feel that though what happened in 2017 is less relevant, then you put it down below in the facts. That's an absolute no-no. That cannot be the situation, or that cannot be the way when you're drafting any, it's not just applies to environmental law but any field of law. When you're in litigation, chronology brings logic. That's the fundamental rule. So make sure when you're drafting anything, when you're drafting your facts on any issue, it has to show chronology. It's all right to first show what happened in 2017 and then build up. Frame your flow and tone of your drafting on how things changed moving forward. You need to keep in mind that judges do read when they are going to hear a matter tomorrow. They will, most of them will read today evening all the cases that are lined up, and they are very fast readers, and they would, that's why to not break any sort of when you read fast and if it is in chronology, then you tend to acquire or retain more information about your case. But if it is haphazard, you say something of 2019, a fast reader will read 2019 and then you jump to 2017. A fast reader, especially a fast reading judge, would just close your brief immediately and throw it away straight away, saying, "Kya, what is this? This is a bad way of drafting. I'm not understanding a word. How this person is jumping from X to Y. So I'm closing it," and then we don't know what happened. Then everything depends on your oral presentation the next day. So drafting is really important, and this flow and tone must be from a point of view of uh, chronology and how things are shaping up. When you know in 2019 something big happened, try to start shaping it up when you're showing things of 2018, 2017, 2018. Use words like uh, you know continuing apathy of the government in 2018, continuing apathy of the officers in 2018 showed X result. Thereafter, then you show the bomb in 2019. Suddenly, you have something like a huge catastrophe that happened, which was just waiting to happen. And eventually, then you can explain what happened, what is the main issue involved after the incident occurring. So this is how these are the few things on when you write the facts. Now, one more very important thing that is again a golden rule for drafting is that you need to know which authorities or who should be the respondents, basically. Whether it is supposed to be certain authorities or it has to be certain private body, it is extremely important to do a thorough research on which is the exact pinpointing authority. Obviously, when you're challenging a particular, say, notification, you're challenging a constitutional validity of any subordinate law or any law per se, then you have to make Ministry of Environment or Ministry of Law straight away as a party. There's no two way about it. But if you are going after a small particular related, not small, but each issue of environment could be of a small area or a big area, could be equally important. But point is, if you're going after a regional specific issue and you're bringing that before the courts forum, then just do not make the larger ministries as parties. You need to do your research, find out who's the collector, whether tehsildar is a pro is the concerned revenue department in the area, who's who owns the land. Is it in most cases, or for example in Navi Mumbai, it's not the revenue department, but it's someone like Sitco. So you check whether they still are the owner, so they need to be made as parties. Then you need to check which, if it's like an issue of pollution or by way of sewage or industrial pollution, then you need to make sure that the industries department of the government as well as the sewage department of the municipal corporation is a party. Apart from the fact that you make those ministries and head of the departments also as parties, because it makes it easier later on. It is very, I'll tell you out of experience, what happens is most of the times when you make slightly general parties, the other side will come and say, no, this is not the correct department, kindly, this is X is not the correct department, Y is the correct department. They are not made as parties. The judge will then ask you to amend your petition, and you will have to undergo a process of amending, and then again you will miss out on 2 3 dates, and eventually then your matter gets prolonged. To avoid all that, do your research on who the parties are going to be. It's very important in my opinion. So moving forward, when you in your facts laid down your of chronology of events that's happening, factual chronology of events, you need to also start explaining. Obviously, after facts come the grounds. In your grounds, you it is important that you show up all the jurisprudential aspects that have been covered by mostly the highest court of the land, but also if your high court of that particular state has also given some good progressive judgments suiting you. Needless to say, those need to be added in short, in a succinct manner. Something like how right to clean water is a fundamental right under Article 21. Now that has been given by way of a judgment in MC Mehta, or something to do with sustainable development or intergenerational equity. Because you are seeking protection of certain natural resources, these doctrines do play a huge role. And you never know what can pop up in the judge's mind, or what can help a particular judge when they read your draft. It could be that that particular judge is more of a judge who understands and implements jurisprudential concepts rather than facts, or I mean in conjunction with facts obviously, but something that appeals to a judge of something. It could be that a jurisprudential point appeals to a judge more, then it is highly likely that you will also you can get a favorable uh, hearing on the day of your hearing. So these things are very important. Your legal grounds do shape. In your legal grounds, you need to add your scientific articles. And it doesn't just mean that you just say, oh, in this article, this was recommended and at annex and marked here too as annexure A is this article. No, you need to give a brief explanation or one para explanation on what was it about, where was the research conducted, and why would it play an important role in understanding the scientific issues in this case, in the facts of this case. So this is how you shape up grounds as well, because grounds here are not on law alone. In environmental law, grounds are also on science. So this is a huge difference which I would say to be noted when it comes to other fields of law. In generally in other fields of law, your grounds only deal with legal grounds, but in environmental issues, law needs to evolve and shape around the science. It is not the other way around. Science cannot change or in terms of what the country's laws are. Law needs to keep evolving and keep shaping. So if climate change is happening, global warming is happening, then the laws need to evolve. Unfortunately, today our laws are actually going the other way. So we are in a very different situation right now. But keeping that aside, this is where as far as drafting goes. Now research is done, drafting is done. Make sure, yeah, after drafting, you need to be fully aware of what are the rules for filing that particular case before the, for example, NGT or before the High Court. Now with the today's pandemic situation, things have changed a lot. Some for very good, some for bad. But overall, one needs to always keep updated. One needs to always change as well and have the idea of evolving themselves. So when this comes to filing, I would say it's a good thing what has happened, because now all your petitions that you file have, at least as far as NGT goes, have turned digital. You need to upload. NGT has set up a particular forum, a particular website where you need to upload your applications, and once you upload within that portal itself, you could see that your defects, whatever objection that the registry has shown, are showed up right there. You have the option to rectify those defects by uploading a fresh file. For example, if you have missed out on a certain address of a particular respondent, you can work out on a new Word document and just save it as PDF and then upload it. And in 2 or 3 days, the registry will clear it and you'll get a final number. Once you get the final number, then your matter will get listed in a particular time. But right now, Western Bench is not functioning. It's the principal bench that is uh, hearing all Western Bench related matters. But the portal for filing remains the same. So these are good things, I would say. These are good things, and these things of e-filing should continue to remain as it is, even after post-pandemic. Now, after knowing how filing functions before your relevant forum, the next important point, which is equally important as drafting, and sometimes it's actually even more important, is how you present before the court. Now, once again, a lot of aspects of environmental litigation will also obviously uh, overcompass or you encompass what happens in other litigation matters. Which once here is foremost to be kept in mind is when the matter gets listed for the first time, it is listed for issuing notice to the other side. The rationale for this always before any forum is that you issue notice basically means that the court wants to hear the respondents by having them file their replies or present in court on the next occasion on the issues raised by the petitioner or the applicant who's come to court. So the court issues notice to the other side asking them to be present or file their replies on the next date. Now, first hearing is very, very important from this. When you issue notice, half of your job is done. But it is about what you argue why to get the notices issued. This is very important. And especially because when on first hearing, generally the court would not like to hear you extensively on merits. You have to show in a succinct manner the most important and relevant portions, what are uh, what are missing out or what are problematic to the court from the very beginning, which means that you need to be prepared with how to start from prior to your hearing starts. So basically you need to have, as much as possible, try and inculcate the habit of uh, learning or keeping in mind what your opening arguments will be for issuance of notice. You need to show a prima facie case that is strong, that is in your favor. So it is important to read up all the each and every page. That's a sine qua non before any hearing. You have to read each and every page, plus note down all the important points and then put them together in two sentences. So, in my opinion, it is best if you can get 2 or 3 sentences written down, and then you just, read it up and be ready to start with those unless the court stops you, and then you have to go impromptu thereafter. You have to go all across and have a complete session of arguments, keeping in mind what the questions are asked. But when you start, you need to be aware of what you're saying. So for some people, it may be beneficial to note down 3 or 4 sentences and be ready. Start with those sentences, but don't have a tone. Your tone should also matters a lot. Don't have a tone when you're speaking that sounds artificial and something like what you do in moot courts. It's absolutely different in the real world. In moot courts, you may have this tone which is in the nature of a robotic monotone where you try to say something which you have already mugged up, but try to bring expressions in your arguments when you're arguing before the bench. Try to use your gestures, not extremely that the concentration goes away and you're using your hands and the judge is not listening to you or looking at your face, but it's looking at your hands. So don't go overboard, but try and show that that this issue involved in this matter is of requires complete careful and serious consideration. Change tones, speak in a manner which emphasizes the fact that there is seriousness in X argument, there is equal seriousness in Y argument, and shape up your arguments and shape up your tone when you're presenting in that manner. And do not ever show any sort of aggressiveness before any bench. That's another golden rule in litigation. Be even if it is not to your liking, whatever is happening, or if the judge is screaming at you, if the judge is saying it's a pathetic draft, you have done, if you don't understand anything, apologize and then trying to say that you will rectify and try to say that I will present in my manner which will now which I'll try my best to put it up in a very short manner, in a summarized tone, and I will finish my arguments within 5 to 7 minutes on this point. Say that the bench, in practicalities, the judges will appreciate it, and eventually they will maybe hear you out. And if you've done a good job in that presentation, you may get a favorable interim order or a final order straight away. So these are the few aspects which I feel are practically important. And with this, I just want to finish the civil aspect. Criminal aspect, what I discussed with you was, it's quite shocking that to initiate the criminal law in motion, or to set criminal law in motion from a private citizen, it takes really long. Now, why I say so is because Environment Protection Act has Section 15 and Section 19 in it, which deals with initiating criminal proceedings against any person, be it an authority, be it a public body or a private body. So you all may be knowing how criminal law can start. One, either you go to the you file an FIR before the concerned police station, or number two, you go file a private criminal complaint before the concerned magistrate. These are the two options. You can either choose one over the other. First is always FIR. If the court doesn't, if police station doesn't seek registration of FIR, then you go after criminal complaint. Now this is the ideal scenario in any in under IPC and CRPC, where you for an offense can directly approach. But what environment protection, especially Section 19, does is that it has a huge, I would say, massive obstruction in setting criminal law in motion from the point of view of a citizen. Why I say so? Because Section 19 clearly says that no court shall take cognizance of any offense except when any person has given a notice period of 60 days to the central government. So if today you are outside your home, you can see some huge environmental reclamation or some environmental destruction happening, and apart from civil remedies that you already have, but one wants to immediately do something as far criminal law is concerned, because obviously some irremediable changes are happening right there. You can clearly see it's an illegal work. They may not have any clearances. So in an ideal scenario, you can immediately go and file and go to your police station and seek registration of an FIR. You can give your complaint, or immediately make a small private criminal complaint and go before the magistrate the next day and say, look, this is the work that's happening. You need to initiate criminal action against them, so that the guys don't run away, so that the accused, the perpetrators don't run away, and they need to be seen with the stern hand. But what, and this is the ideal scenario, but what Environment Protection Act does, Section 19, which I completely feel this is absolutely constitutionally, it's incorrect and is invalid in the eyes of constitution, which needs to be challenged as well, is that it gives places an embargo of 60 days, that no private person can go and immediately file an FIR or a criminal complaint before the magistrate unless that person gives 60 days notice to the authority. Now we know how things function in India when it comes to authorities, and you send a representation, they will sit on it forever, they won't even reply. So you're losing out on 60 days when it comes to an environmental issue, and things can just change overnight in environmental issue. Like, even from a criminal point of view, from a criminal jurisprudential point of view, having, for example, uh, someone given 60 days, that person who's an accused can clearly destroy all the evidence that he has. Whatever machineries that he or she may have used, he can take it away and run away. So there is, once after 60 days, when you try and initiate a filing of an FIR, the damage is already done and the perpetrator has run away. So this is a very big problem in my opinion. Criminal setting. That is why you see not many rulings or judgments on criminal law, on the criminal side of environmental crimes. So which is very unfortunate, and I believe time has now come to challenge this particular clause and declare it unconstitutional. Assuming you have given 60 days notice, then all your CRPC and other provisions of IPC, such as public nuisance, public health, can be added to the FIR or the criminal complaint before the magistrate to Section 15 of EPA, and then you can initiate a criminal trial. And all the rules of CRPC will apply. So that is an entirely whole different session. So then your criminal law is set in motion for an environmental crime. But having this 60-day notice is something which is highly unconstitutional in my opinion.
So meanwhile, Zaman,
Yeah.
can you highlight the remuneration? What are the revenue in these kind of cases?
Okay. So yeah, see, this is a public law remedy. Okay. I would say the remuneration will be pretty low. There's no two way about it. It will be low in the beginning, but a lot of law firms, a lot of council practices that you see from on the councils, chambers of councils are slowly taking up environmental issues, which they feel dearly to. So though the pay is obviously less in comparison to other branches, fields of law, but it is not so less that you cannot survive. Plus, the satisfaction of doing such work is immense. So somebody who is living in a city like Bombay, I would say, and has to not fortunately worry about rent for their home or something at some ways who has a home, then they can always think of doing this public law remedy at the same time with other branches of law if they are practicing with some councils or something. So though the pay is less, but it has immense satisfaction. And even other than that, there are now many organizations. I can name a few like One Shakti, Bombay Environmental Action Group. All of such organizations are also now in increasing their space for more law officers, for more legal help that since they require. And why they are increasing it, because even the general public is understanding that such organizations need to also be slightly funded. And things are changing, people are definitely becoming more sensitive, though we are way behind. But it's a cycle where if when you enter the field, you will realize that it's not so bad, I would say. So I can't give you a fixed sum, it varies from case to case basis, but anything around 30 to 40 can is workable.
Okay. Like, you've such high profile cases, you've litigated. So did you ever get any threats? I'm sorry. Did you get any threats or political pressure?
No, no, not at all. Not at all. And I don't see any scope either, because it's not just like a one man army is happening. There is never a one man army when you have lawyers applying. So it's not like I am a petitioner either. But point here is it's a huge, concerned people. There are whenever we file PILs or we do such cases, we are always looking at a policy issue as well. What is the policy issue involved in such issues? When you see that judges are appreciating, you have that inbuilt confidence that then starts getting displayed all across with people, with citizens, with students, with media. Eventually, with this, I would say, with this atmosphere created by this particular by this set of people, I would say there is no scope of I feel being very fearful, or there is no scope of
Mhm.
getting any sort of threats either. So nothing to worry about. It's an entirely proper public law remedy. Yes, I know few people as well in my circles who have been receiving, but they are not lawyers, but they are all people who are on the ground. And like mining issues that are involved in parts of Goa and things around there, sometimes you feel like a dreadful situation, but it is not really as bad as it sounds. And nothing to lawyers, I would say. So it's not that easy for people to come up behind lawyers as such, who are just practicing in courts and putting the plea out. Because this is not some sort of an activism where you are trying to just going after a certain private person. No, you're always going against the government. Most of your matters in environmental issues are on government policies, where government has gone wrong, where government has been arbitrary. So with this aspect, there is no scope, I feel. And I have not faced either, so I am 100% sure there is no difficulty. If someone is thinking in those
Okay, good
lines,
to know that.
there is no problem. Yeah.
And see, in the past, we have seen that the judiciary has played a very instrumental role in enforcing the environment policy. I want to know from you personally that what is the attitude of the judges when it comes to these kind of matters?
So, very good question, because the answer lies in the fact that, and many eminent lawyers have also said so, practicing in Supreme Court, that there is not one Supreme Court. There are literally 12 Supreme Courts, in within one Supreme Court, because each bench works differently than the other. See, ultimately, how much ever we say, there are certain prejudices and biases of judges that they carry, and to what extent can they uh, try to not retain them? To what extent can they let go of those prejudices do matter. But mostly, this is an issue. Environment is an issue where overall, I would say, the sense has remained low. It is only in the few judges when you tend to know which judges, when you practice, you tend to get an idea of what kind of judges deal with which kind of issues and in which seriousness, in what seriousness. So ultimately, you feel that you have to strategize yourself based on what kind of bench it's going before. This is a real practicality in law. You need to also shape your arguments around what. But as far as the judgments go, yes, the judgments that we received in 80s and 90s, I would say, are exceptionally good. That has helped shape jurisprudence a lot. But eventually, we have seen that a lot of times for a similar issue, when industry or a particular uh, you know uh, project proponent, a particular project has been set up in a forest area illegally, how that is treated compared to something like a a small encroachment taken by some poor people because of various life related issues. The way they treat both issues on for the same forest land is something which is absolutely discriminatory, in my opinion. So there are judgments which favor the environment most of the times, but it has always been, or rather, I would say most of the time, it has been the environmentalism of the rich that they have favored. Something like keeping your national park protected. But what about ensuring those traditional communities, tribal communities in a forest area that have lived there for generations? Then industry might just be 30 or 40 years old. You have an entire community in a forest that has been helping improve the forest for 300 years. So that sense is not there in the judiciary. They do not consider that part as something which needs to be read along with your protection laws. So there is a huge discriminatory practice. Most of the time, environmentalism of the poor is gone on the backdrop, and environmentalism of the middle class is gone, is taken as, is projected as something which is good. So this is where the Supreme Court judgments and High Court judgments are where I personally feel. But as far as NGT goes, NGT was doing a fantastic job, I would say, until 2017 and 2018. Thereafter, even NGT, the quality of judgments have gone down. You can blame the higher judges who are involved as well as who are included. But the point is, because the whole idea of improving jurisprudence, improving society has gone down. Now we just see that the respondent, the matter in many cases, we just see that authorities or bodies that are respondents in the matter, NGT just makes a committee of those very respondents asking for a report. Now that is against the principle of natural justice. Why a person cannot be a judge of his own case? So we are seeing a lot of to and fro today, and overall the environmental sense in judges is still remains largely low. Therefore, it is the duty of that particular lawyer who's arguing to, try and bring some sense and improve the environmental sense by arguing. So
Okay. So I want to know, research involves a lot of things. So what about the cost incurred when conducting the research? Some cases might require a lot of extensive research. So is there a lot of cost incurred in that?
so not really. Answer is no. And I want to know, when you look at cost of research, I want to know from where you're looking at, because if you are a lawyer, you are trained to be a researcher in your law school as well as moving forward in your life. So you are trained to understand what is a good source of law and what is not a good source of law. And most of the time, when you are on internet, thanks to internet, you have so much of scientific journals that are now available for free. So you do your research, even if you're starting on science. See, judicial research, everyone knows Manupatra SCC will play a role. But as far as scientific research goes, you really need to begin from all these scientific journals, or rather start from Google itself and try to find correct research articles. And I would say there is literally no cost if you know how to research well. And if you're seeing this is only from a point of view of a lawyer. But if you're looking at from a point of view of a research organization who wants to first conduct a thorough research before filing a case, then that research organization might need to do a complete research from the scratch, which might include to go onto the site, conduct a site visit, take samples, carry out a research in their lab, and then come up with a full-fledged report, based on which report a litigation case is filed later on. That could happen, and that could entail certain cost, obviously. But this is how I see the difference in research.
Okay.
There could be people who you're fighting for who may not have any relationship with any such research organization. They have no idea how to research. They have no idea how science functions. You need to help them as lawyers as well. Find out articles from the journals and try and build up your case.
Yes.
Yeah,
You've been a part of the coastal road litigation. So I
right.
request you to share some experiences with the participants.
So, coastal road petition was actually filed first in the NGT, and then it was taken up before the Bombay High Court. And Bombay High Court passed an immensely good judgment by Chief Justice Pradeep Nandrajog, as he then was. And it was a fantastic judgment of more than 100, about 160, 170 pages, dealing with how reclamation occurred back in the British era for Mumbai, and how that reclamation was different from today's reclamation. Apart from the legal arguments, I'm just dealing with the logic behind how that cannot, because see, generally we saw that the municipal corporation and the state came up with the argument that this entire city is built on reclamation. The 7 islands have been connected. Why are we talking about reclamation now? What is the problem with reclamation now? All these issues. So we put up a basic scientific article showing how the carbon emissions have increased from now compared to what was in British era days. What is the future now in climate change compared to what the climate was back then? What's the repercussion of global warming now compared to what it was? Just because something happened in the past doesn't mean it's good forever. So now the things are different. We need to see from our lens of today. So this is what all of this was also covered in the, not entirely the way we would like it to be, but it was covered in the High Court judgment, and under the precautionary principle, and also on the fact that the procedural law was not correctly followed. The High Court struck down the environment clearance granted to the municipal corporation for coastal road, and by that time some work had already begun, and that was a big win for us. We straight away won at the High Court, but eventually when it went up to the Supreme Court, unfortunately the Supreme Court straight away from the very on the very first, not on the very first day, but eventually when we had a new Chief Justice, at that point of time, Justice Bobde, as soon as the matter came up before him, he stayed the Bombay High Court judgment without providing reasons. In fact, the reasons that were provided was that it will cause irremediable injury to the contractors because they have paid so much amount. Now, the concept of irremediable injury must be seen in environment matter from the point of view of environment. That if you reclaim a particular entire coast, that is irremediable. Tomorrow you can't bring it back. You are literally, you may not believe, but then there are rocks on the Worli sea face that were 80 million years old, which had an entire different marine ecosystem on those rocks, which unfortunately our research, our city has given so many ocean scientists, oceanographers to this country, but we ourselves haven't conducted any study of our coast. But during this coastal road matter, when it was going on in the High Court, we had conducted, marine biologists had come on ground, prepared a report, and we were surprised to see so much of biology, marine biology in those intertidal shoreline areas. It was unbelievable the kind of photographs we have. And all of that is now gone fully. So that is irremediable. You can't bring that back anymore in any case. But instead of using the argument of irremediable harm for protecting the environment, which is the correct jurisprudence, the court proceeded to say it will cause irremediable harm to the L&T, to Larsen and Toubro, who are the contractors, and to the municipal corporation because they have paid so much money. So once again, it was a clear-cut case which didn't make any environmental sense. And eventually, the Supreme Court stayed the Bombay High Court judgment, because of which the work is going on right now. And the Supreme Court is now, unfortunately, many a times we have tried to move this matter for final hearing. Supreme Court has not listed this matter for final hearing since about more than, I would say, 8 to 9 months. So now it is just an empty cause, in my opinion. It's quite unfortunate that this happened at the level of Supreme Court.
I want to know the most important landmark judgment to work in this field?
I would rather not say, and would request you to put some efforts and find by yourself. But to be honest, okay, since you put it up right here, I would say there is MC Mehta versus Kamal Nath, which actually helped in shaping a lot of good jurisprudence on doctrine of public trust. Doctrine of public trust is a very important doctrine in environmental issues, so as well as on polluter pays principle. So this is one. Then second is the Indian Council for Enviro Legal Action. Then which also pertains to coastal regulation. Then you have plenty of MC Mehta matters actually, starting from the Bhopal gas leak as well as from oleum gas leak, which was in Delhi. Then you have of the whole Delhi air pollution issue as well. So if you want to improve the jurisprudence of in the latest point of view, then I would suggest from the latest series of judgments from NGT, I would say you read two judgments, which is one is of Wilfred, which is written by NGT judgment. Though it is an appeal in Supreme Court, it has not been set aside. Wilfred versus I think Union of India, and second judgment would be SP Muthuraman. That is also of the principal bench of NGT. So these two judgments are also important. But otherwise, if you do your simple, put in efforts, and you will find great, really good articles on the internet on dealing with all landmark judgments. People can reach out to me on Twitter on my Twitter handle, which is Zaman Ali 23. So that's my handle. Plus, you can also send an email to me if you have any queries. It is Zaman Ali 1602 at the rate gmail.com. So Zaman Ali 1602 at the rate gmail is my email. I'll be more than happy to respond back on any query in my time when I'm free, surely. Thank you so much for having me.